Join us live every Tuesday from 4 p.m. to 5 p.m. Eastern Time on GluFM for Minding Your Business with me, Attorney Rishma Eckert, to discuss the law and your business. Email us with your questions at info@mybshow.com. And remember, success comes from minding your business. Welcome to another episode of Minding Your Business. I am your host, Rishma Eckert. I'm an attorney with Eckert Law, PLLC. And today we are talking about closing your business. I got the inspiration today because the Florida Bar Journal has its article about the anatomy of a business divorce. And I thought to myself, how very apt, because now that we've had about a year or so of the pandemic, there's lots of businesses that are closing down, unfortunately. There's also a lot of people starting businesses who have been unemployed. So it's kind of like a weird place that we're in as business owners and entrepreneurs, kind of like the birth and the death at the same time. And when I saw this article, I thought, well, I definitely need to do another show about how to go about doing that, because I have had some inquiries on, in my day job side of it, where people have been asking me, and there's just a lot to consider. And I want to be able to talk about that with you guys today.
And what you said, Rishma, a lot of people, I just want to add that when you talk about divorcing your business, it might not be like shutting down your business entirely. What is happening is a lot of people have to divorce the old method of conducting their business and try to adapt to the new way of doing things. So that sense.
Yes, that's a good point. That's a good point. That's not considered in this show, but you just gave me an idea for another show, because you're right. If we're talking about revolutionary businesses now, the ones that are going to be able to stand the test of time, it's a different way of doing things. And it's not just a matter of, well, I'll just go remote. It seems to be an entire mindset that's been shifted in the business community. But that's a good idea. I'll put something together about that. Awesome. But the article specifically is talking about divorcing, meaning like, you're shutting down, you're separating from your partners. They use the word divorce because it's pretty much like a marriage when you're in a partnership with someone in business. Yeah. So, it's sort of some of the same procedures, but I'll definitely give you considerations today to think about some things that the article talked about that, not that I haven't considered it, but I never considered maybe telling my clients this, because some of it is legal, some of it is financial. So it kind of like straddles a lot of different areas. So I thought this is perfect to get that information out there to our listeners. Just a reminder before we get into the meat of it today is that at the end of this month, the PPP program is going to have its deadline. So if you are still looking for funding, they haven't made any announcements of running out of money yet. So that's good. Now, like the first round, the money was gone like that. So if you want to be able to just look and see if you have the option of getting that loan, go on the SBA.gov site and see, maybe you're eligible, maybe you can get some funding and help for your business as well. Also, and I have to say it over and over, annual reports were due May 1st. So if you did not pay on May 1st,
you're late.
You are late, and you have to pay a $400 filing fee. But you have to, if you are in Florida, you have to file an annual report. You have to do it. That's part of the law of when you incorporate your businesses. You will have to pay a filing fee now, but if you do not pay around September, I believe it's the middle of September, the state would administratively dissolve your company. And you definitely don't want that, because then you're going to have to pay to get it reinstated. And you're going to have to pay all the backlogged annual fees as well. So you don't want to be in that position. And some of my clients have asked me in the past, well, what does that mean, that I'm administratively dissolved? What it means is you no longer own a company. So that is something that you definitely want to make sure that you talk about. Then let's see what we have here. Small Business Spotlight. This is becoming one of my favorite segments actually in the show, because we get to highlight some of the small businesses that are around us. If you would like to be considered for the Small Business Spotlight, please make sure that you email me at info@mybshow.com or send me a message on the Minding Your Business Facebook page. I've actually had a couple of people message me directly, and I am the person behind that Minding Your Business Facebook page. So when you message, you can talk to me. And so we can try to set up something. I'm working on something very special for Caribbean American Heritage Month to be able to spotlight a very important business in our community. And it's tentative, so I don't want to say it right now, but I'm hoping, crossing my fingers, that it's going to work out, because it's actually, I have to go through several layers of people to be able to get someone to confirm. So I'm very excited about that. So that's going to be for June, but we're trying to highlight a business every month. This is a great opportunity for you to be able to get your business out there, get some marketing, put your products together, your services together. And we are, as Lisa said, everywhere: Florida, Kentucky, New York, Canada, UK, Africa, Asia, parts of Asia. So this is definitely something that you should consider in terms of your marketing. And also, as Lisa mentioned, the videos are posted on YouTube, so you're always going to have access to that for your own purposes. SMYB, if you would like me to discuss a topic that you have not seen me discuss before, or you want me to expand on a topic that I've already talked about, please go ahead and email at info@mybshow.com. I've turned questions into shows, which is great, because for us, it's all about giving back to the community and providing resources for our listeners.
Yes.
So my quote of the week, and I absolutely love them. I say it every week, but it's true. I only pick quotes that I absolutely love. This one is from Thomas Edison, and he says, "I have not failed. I just found 10,000 ways that didn't work." And I thought that was very, very important for our show today, because we're talking about closing down a business. And the stigma that goes with that is, well, you failed, you couldn't make it work. You are, I've talked to a lot of business owners that either had to separate from their partners, business partners, or those who had to close on their businesses. And it does come with some degree of depression. At least that's been my experience with my clients. And I always try to spin it a different way. Like, look, everyone tries and fails. The most renowned entrepreneurs out there have tried several businesses. If you look at Richard Branson, the owner of Virgin, he talks about it in some of his books and interviews about all the different businesses he's tried in the past, and they've not worked out. But one thing you do in life, I always say, you don't ever lose. You always win or you learn. That's my saying that I tell my kids as well. You don't ever lose. You either win or you learn. And so I look at business the same way. If something doesn't happen to work out for whatever reason, it's a learning experience. So when I saw this quote from Thomas Edison, I thought how applicable to our show about closing businesses, because you've not failed, you just found ways that it didn't work. Right. And guess what? If you want to try again, you know what's not going to work. So this time you try it again in ways that are going to work. Right. So it's all a learning experience. I mean, no one has the manual. Even me, as a business law attorney, if you consult with me, I can tell you the laws. I can tell you what may work based on my experience, but I don't have 100% guarantee. I can't tell you if you do this specific thing and you take this specific course of action that you're 100% always going to be completely successful and you'll be the richest man in the world or richest woman in the world. I can't say that. All I can say is that these are the guidelines that you have to follow. These are my suggestions. And that's why we talked about mentorship in some of the programs before, how important it was to have mentorship as well. Yes. It's just, it's a learning experience. So if you are in a situation now, especially after this pandemic that no one could have predicted, if you're in a situation now where your business is in decline or you've been forced to close down, like we'll talk about it today, I don't want our business owners, our listeners to feel like, oh, well, I've failed. No, we'll use that as a learning experience and we'll move forward. Whether it's with a similar kind of business and you try it a different way, like you talk about reinvention, or you try a different type of business, or you do something else, it doesn't matter. You're always going to be able to learn from what you do. So love that. Absolutely love that quote for the week. So closing down your business could be a it's a very personal decision. And it's not something that you just wake up one day and decide that you're going to do, especially For some of my clients I've seen that have been in business for a very long time. I'm talking over 10 years. They've been in business and now they're considering closing it. Think about it. This is definitely something that you want to have some, you sleep on it, you crunch the numbers, you figure out your plan. This is not something that should be taken lightly. This is something that you should really sit and think about and have contingency plans in place. But if you do decide, okay, this is the course of action I want to take, and I definitely want to close my business, do it properly. I can't stress that enough. There are lots of guidelines that you will have to follow, things to consider. Like I mentioned, I saw some things in the article that I thought, oh yes, I definitely have to add that to my list of things that I tell my clients as well. So let's talk today about what you need to do, some of the considerations, and the most important question I ever get from any of my clients. Am I going to be liable for the debts of my company? Number one question that I get all the time, and we'll talk about that as well. So if you're considering closing your company, or you just want to have this information to store at the back of your head in case that day comes, this is the show for you. So let's talk about it. What do I need to do to close my business? If you are a sole proprietor of a business, you don't have to file any paperwork, because technically, if you're a sole proprietor, it means that you have not filed any incorporation paperwork. These are people who have not been on Sunbiz, who have not filed any documents with the state. They're just conducting business by themselves and they're calling themselves a sole proprietor, and that's fine. So if you have to close down, you don't necessarily have to file anything now. You're just going to be out of business, and then you will do some of the other things that I'm going to talk about later with our considerations, but you are not required to file any paperwork as such. Different situation if you are an LLC or a corp or an Inc. Now you have filed with the state, so you are technically a business with the state. Do you want to wait until they administratively dissolve you? Probably not. You probably don't want to do that. You want to be in control of the way that you wind up your company or how you liquidate your company. So what you would want to do for LLCs, you will file articles of a dissolution, just as you filed articles of incorporation or articles of organization for LLCs. You will have to file articles with the state. I had one client tell me, wait a minute, I have to pay to close down my company? Yes, you do have to pay to close down your company. The same way you paid to open your company, there is a filing fee involved. Now, the filing fee is less than it is to incorporate. I can't remember off the top of my head what it is. In Florida, it's something like maybe 25, 50 bucks, I'm not sure. But it's not the same as when you were getting your business started. So if the question is, what do I have to do? You have to file articles of dissolution. You must file, because otherwise you will see in the state records that your company is still there. So when you file for dissolution, it's recorded with the state, and then your company is seen as dissolved. Very important. If you have a corporation, now corporation, I mean corps and incs, you are in a completely different category than an LLC. Think about it as a company, two different types of companies. On the LLC side is one thing, and on the corps and inc side is another thing. Corps and incs have more corporate formalities than LLCs do. More meaning there's other things you need to do to make sure that you have a dissolution or how you run your business. It's just more corporate formalities. That's just how it is. So for both of them, you have to file articles of dissolution. And then for the corporations, you might have to file notices as well. And we're going to get into that. Very, very important to note. And I say this almost every show we talk about contracts and corporate governance. Very important to know. The way that your company is going to be closed is going to be dependent firstly on your corporate governance documents. Meaning, if your LLC has an operating agreement, the operating agreement will have in it how you can go ahead and dissolve, what you need to do besides just file the paperwork. What are the conditions and etc. Also, with the bylaws for a corp and an Inc., you should have provisions in there about what happens when the company gets dissolved, how it can be dissolved, what happens afterwards. You always firstly go to your corporate governance documents. Now, if you don't have them, does it mean you can't get dissolved? Of course you can. It's just that now we have to go to what our Florida statutes say versus what you can get together with your partners and agree on. So I always encourage you to get a corporate governance document of some sort, because then you are in control of your business rather than the Florida statutes being in control. You have an opportunity to control how your business is going to be closed down, according to the law. So let's get into a little bit of it. So you file articles with the state. That's technically what you do in order to show that you're going to be dissolved. Now, very, very, very important. I cannot italicize, unbold, and underline this enough. If you have a multi-member LLC, meaning that you are not the only owner, and you file your articles of dissolution, you must get consent from your partners to do so. And without boring you guys, I will read you one line of the Florida statute, because I do have it in front of me. It says that the events causing dissolution of an LLC is by, quote, the consent of all the members. The consent of all the members. So you, as smart businessman, thinking, I don't want this business anymore. I can't agree with my partners. I don't want to continue with them anymore. In fact, I hate all of them at this point. I'm going to go ahead and I'm going to file these articles of dissolution, and I'm going to sign it and I'm going to file it. That's in a violation of Florida statute if you do not get the consent of all the members of your LLC. This is for LLC, all the members. So there's a couple of things in the Florida statute that specifically talks about the events that can cause a dissolution. And this is the one that trips most people up, because they're fighting with their business partners and they decide, screw it, I'm just going to go ahead and dissolve the company. You cannot do that. You have to have consent of all your members. If you do not do it the right way, you are in violation of Florida statute, and you can have some serious consequences against you. So please, if you're disagreeing so much and you hate each other, at least you can agree on one thing. You don't want to be in business with each other anymore. At least you can get the consent to dissolve. If you don't agree with anything else, make sure that you have it somewhere in writing that you all have disagreed and you don't want to continue the business anymore and you want to go ahead and dissolve. At least that would be consent of all the members, and then you don't have issues afterwards. And I'm stressing this because I've had a couple of cases like this, and it's so frustrating to deal with without cutting and pasting the Florida statute to let the business partner know that what they're doing is wrong, because they think that, well, we couldn't agree. And some of the reasons that they put on Sunbiz were, we couldn't agree. Or, they will put all these explanations, and I have to explain to them, that is not what the statute says. It has to be consent. Very important. For Incs and Corps, because it's very different, we have to make sure that we are doing resolutions. Now, if you are an owner of a corp or an Inc., you should already be in the habit of passing resolutions when things happen. So you have a meeting, you pass a resolution. The board of directors pass resolutions. That's how you do business if you have a corp or an Inc. So you should already be in the habit of doing that. And dissolution is no different. You will have the board of directors proposing a dissolution, and then the shareholders are going to be the ones approving it. And that's how you go through with the necessary documents to have that. Now, this is also with filing. So I don't want people to think it's either or. You file and you have to have these different things in place as well. That's a technical way of what you would be doing. Now, why is it important? We'll get to the notices afterwards when we talk about the debt part, because I know that's what everyone wants to hear is, am I going to be responsible for the debt? We'll get to that. So you would have to have a written consent by the shareholders, or some sort of resolution that shows that you have all agreed to do so, or that the majority has voted to do so, and just some sort of internal backed up paperwork to show that this was the intention of the company and not just one person deciding that they don't want to have business partners anymore. So before we get to the debt part, what else do I need to do? Like, what else? Okay, so I filed dissolution. Am I done? Technically, on the state side, yes, but there's a lot more to consider for running a business, as with everything else. It's just so much. If your company is one that had a license, let's say you have a permit and a license, because we talked about the Department of Professional Regulations the other day in one of our shows, you might want to consider, if you're going to be done with the company and a license that you have is actually attached to the company, meaning that the license is for the use in that company and not for the person, then you might want to go ahead and cancel that registration. So I know some of other professionals, the license can be attached to the person, and then you can go from company to company with your personal license. Or some companies, though, it has to be attached to an actual legal entity. And you don't want to have that over your head in case you want to go ahead and open a new company or work somewhere else. So if you have licenses that are attached to that company that you're dissolving, make sure that you go out there and you cancel those registrations, you cancel those permits, cancel any fictitious names that might be registered under that company name, because now the company is going to be gone. We have to make sure that we're completely getting rid of all the collateral stuff around it as well. You can also, what you also have to do is make sure that you take care of your employee situation. Because now if you have people who are employed by your company, you have to do all the final paychecks. You have to make sure that all of the IRS reporting is done, that you abide by all the state and federal laws when it comes to final paychecks. You cannot, and I've had this happen with one of my clients as well, you cannot say, well, we don't have any more money, so it's too bad you can't have your final paycheck. You just have to wait, or what are you gonna do? No, you can't do that. You have to make sure that part of your winding down is making sure that those employees can get their final paychecks, because you have to. I mean, it's required that you pay people for their services. So you have to make sure that you square away what you need to with your existing employees. Other IRS considerations. Now, what happens to that EIN number that you have? Don't forget about that EIN number that you have attached to your company. You have to now contact IRS, and you have to make sure that the IRS can cancel that. And sometimes they can do it by sending they still do faxes. So you can send a fax to them trying to say that, you can attach the dissolution paperwork and say this company is no longer active. Can you get rid of or, park the EIN number? I don't remember what the technical language is, but you have to do something with the EIN number. You also have to handle any final returns. So you might want to get with your bookkeeper or get with your CPA and just make sure that you're handling the finalization of the taxes for that business. It might not be the end of when you decide to go ahead and dissolve, it might not necessarily square away with the end of your financial fiscal year. So if it's halfway, I'm not a CPA, so I'm not sure what they need to disclose, but you definitely have to get with your financial or your tax professional and make sure that you square away sales taxes, that you square away, we don't have income taxes here, but like employment taxes. You have to square away everything to make sure that you don't have any more issues with taxes and the IRS. Also important, remember that you still have an obligation to keep your records, your incorporation paperwork, that's public record, but like anything, legal contracts, your financial information, especially IRS information, employee information, you still have an obligation. And depending on what it is, sometimes it's between 3 to 7 years that you have to keep certain things, but you can always store it either electronically, store it in a box somewhere, but you do have an obligation. So it's not like good riddance, let me just burn everything to the ground and be done with it. You do have an obligation to maintain certain records over a period of time, usually 3 to 7 years, just depending on what that record is. Especially, my rule of thumb is with IRS information, I scan everything and it's in my computer and it's on the cloud somewhere, because I don't mess with the IRS. They scare me, so I don't mess with them at all. Definitely your finances.
Is there an exception to the IRS? Because if the time frame, let's go with 7 years, right? Up to 7 years, you have to hold on to those documents, and say the IRS is coming after you about that business 15 years later. I mean, how does that work? How
so if you're out of that area where you don't have to keep it anymore, you can just request what it is that they're asking. I mean, they will have to show you proof of what you're doing wrong, because every client that's come to me with an IRS issue, it's during the fiscal year of whatever, you didn't report this much, and here's a copy of your tax return. So they give you what it is that that they think that you're not compliant with.
They're terrible. I mean, it's good.
They're doing their job. I have to defend them that way. They're doing their job, but because they're so good at doing their job and they're so meticulous, is what scares everyone, including me, because I don't do taxes at all. At that point, I would say contact your tax professional. I will call Karen Ross immediately. And Karen Ross is one of our previous guests on the show.
Yeah.
I would call her immediately because she's also an EA, which is an enrolled agent. So she can act to represent you in tax matters. That's the highest you can go in terms of tax representation. And a tax attorney. I mean, the EAs are right up there with the tax attorneys. So at that point, I would just call Karen Ross and be like, look, what do I need to do? Because and you can always explain to them too, my statutory requirement was 7 years and now they're asking me 15, 20 years later, what do I do? I'm sure that there's lots of ways to handle that.
And by the way, guys, if you are in that situation and you need to get in touch with Karen Ross, send an email to info@mybshow.com and Rishma will connect you.
Absolutely. Karen is now my go-to person, my husband's go-to person. Ever since we learned more about what it is that she actually does. And, people think, oh, like my tax person, my CPA, you don't really have an idea of what someone does until they break it down to you.
Yeah.
Even when I tell people, like, I do business law, they're like, okay, they have no idea what it is that I actually do. So when I heard her show and, I met her through one of my other networking, I thought, wow, this is just fantastic. And this is someone that this type of person is someone that you want to have in your life if you are a business owner, because you're always going to be getting tax issues. You're always going to need to know what's the next deadline, sales taxes, employment taxes, all the things that she broke down when she was on the show. Mm-hmm. Listeners, if you want to go back to that show, is that on YouTube as well?
It's on YouTube.
Yeah, go back to the, I don't remember what I called the show, but the special guest was Karen Ross, and she is an enrolled agent and a CPA.
Taxes.
I think it's called taxes.
Yeah.
I think you're right.
Yeah.
That's how much I'm like, taxes. I don't know what else to say. But it is a fantastic show where she breaks down a lot of what business owners need to do and consider when it comes to taxes for their business. Mm. And it's just, if you are not up to speed on a lot of these things, or you are not like me where I want to be bogged down by all the IRS details, it's great to just be able to delegate that.
And you guys might be listening and wondering, well, they're talking about closing your business, but you're talking about taxes. Yes, we're talking about taxes because, like you just heard, the IRS can come after you about taxes so many years down the line, about a business that you closed donkey years ago. So taxes are very much important even after closing your business. Right. You still have to file. So the remainder of the time that you file, let's say if you decided it's May 18th, you decided today that you want to close your business. That doesn't mean from January to May that you're free and clear, right? You still have a period of time that you have to be able to just wind up your business and file those last returns or whatever the case may be. And I want to note here too, since, I'm going a little bit tangential, but when we talk about sales taxes, that is governed by the Florida Department of Revenue. So when you see letters, because I don't think they ever email you. When you see letters from the Florida Department of Revenue for sales taxes, that is something apart from the IRS. And that is also something that you have to take into consideration. Because again, I've had clients who have owed sales taxes for a really long time, and now they want to sell their business. And, it's always these clearances that you have to get before you can go ahead and sell. Same thing with closing. You want to make sure that you're squared away because you don't want them coming after you either. Isn't it funny how you don't really realize, and I hope this is, not any of our listeners, but it's crazy how you don't realize how many problems you had with your business until it's time to close.
Yep, close or sell. And, I'll touch on sell in a second. Well, at the very end, if I have time. But that's usually when it comes up. It's like, okay, we're winding up. We're being done. We don't want to have any more liabilities. We want everything just squared away and tucked in a corner and move on with our lives. And then you have all these things that pop up. Yeah. And I usually see it in terms of selling when we try to get what's called a tax clearance. And I've seen this a couple of times, unfortunately. actually many times, unfortunately, where we try to get tax clearances from the Florida Department of Revenue, and they're like, but wait a minute, you haven't paid the fourth quarter of 2017, the third quarter of 2018, the second quarter of, I mean, they have all those records of things that you owe. So unless you want to just, pay it or have your buyer take the risk, it just depends. And it's usually a sticking point. I had one company that, one person that I had represented where I've actually told them, don't go ahead and buy unless we have all these clearances in place. And then we had to do something else to be able to get those clearances, because they always pop up last minute, right when I think I'm closing. And then they pop up and you realize that there's owed money. So I'm saying the Florida Department of Revenue, if you're in Florida, and the IRS as well, because I don't want you to think that, well, I paid all the IRS money, so I'm done. No, sales taxes is something different. So you just have to be aware of what you need. That's why it's always good to have a tax professional in your corner.
Yeah.
All right. My main question, will I be responsible for my business debt? Now, I have to caveat this with saying that generally speaking, and again, generally speaking, caps, bolded, italicized, underlined, generally speaking, you are not going to be responsible because your company is a separate entity from you as an individual. That's where you have the LLCs. That's why you have corps and incs. That's why you incorporate it, because you want to be a different entity than your business itself, generally speaking. However, for corps and incs, one of the ways that you have to dissolve is to give written notices to known creditors. And this is by Florida statute. This is not me, Rishma, making this up because I love writing notices. No, this is the Florida statute. The Florida statute says that you may dispose of known claims against the known creditors by giving written notice to them. And the statute is very, very detailed on your written notice must have the name, the debt, the blah, blah, blah. It's very spelled out in the statute of what you have to do for your known creditors at the time. Why is this even important? Why do you even have to do these notices? I'll tell you why. Because if they do not respond after getting the written notices in a certain amount of time, I think it's something like 3 years after you give the notice, they are then barred from claiming afterwards. And that is what you want as a business owner. You want to have some bar to them bringing suit against you. Right. And if you can go to court, let's say 15 years down the road, they want to sue you because in 2000 you owed them whatever, and then you closed your business. If you can pull out that written notice and say, look, I sent this to them and they didn't respond, then they're barred from that suit. So it's really, really important. Corps and incs, not LLCs. The statute is specifically for corps and incs, says that a claim against a dissolved corporation is barred when they give these certain notices, and it gives them a timeline to be able to respond back. I mean, it's very detailed. The statute talks about if they respond back, you can either accept or reject their claims and give them time to bring a suit against you. This a whole long thing that they've written in terms of settling debts for a company that's being dissolved. But the best case scenario, you send a notice, they receive it, they don't bring a lawsuit against you, and in a certain period of time, and I believe it's 3 years, they can't bring it again once you've given the notice. Now, if you don't send that notice, fair game, right? Because you didn't actually let them know that you were dissolving. So the notice is very, 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 very important. And I always recommend for my corps and my inks, if they tell me I want to dissolve, I have a checklist that I do with them to make sure that not only am I just filing articles, because it's not just filing, as you can see by everything that I'm telling you right now, it's not just filing articles. You have a lot of winding up and liquidation that you need to do as well of your business assets. And like I said, all the IRS stuff, the employment stuff, the sales tax stuff, all of that has to be done. And importantly, if I see that it's a corp or an inc, I do my written notices to my known creditors. Very, very, very important. Other thing, because I see that you want to ask a question. Another thing, you can do the written notices, and you can also file on Sunbiz. It's called, let me pull it up, a notice of corporate dissolution. It's on Sunbiz along with the dissolution paperwork that you can file as an option, or you can also publish it. So they give you, the statute gives you different ways that you can go ahead and get the notice out there. Publication is one of them in a newspaper, and it has to run a certain amount of time, whatnot. But the point is, you give your known creditors notice so that if they do not respond and they do not try to make a claim, which you have the ability to either accept or reject, and probably even negotiate down if they know that you're closing up your company, you could probably even negotiate that down. But at the end of the day, if you give that notice and they don't make a claim, meaning that they haven't taken you to court for it or anything like that within a certain amount of time, they are barred. They are barred from coming after your company anymore. Very, 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 very important. You had a question? I saw that you had a...
You answered it.
I answered it? Okay. So let's see. I also have here other claims. Yes, so you can publish a notice of corporate dissolution. Here it says in the statute, the notice shall appear a week for 2 consecutive weeks in a newspaper of general circulation in the county that your business is in, and blah, 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 blah. I mean, it's so detailed about the things that they want you to put in the notice, because it gives people an opportunity. And in all fairness, you should give your creditors an opportunity to settle up their debts once you decide to wind up your company. I think that's fair too. And what does this do? This prevents people from creating corporations, doing some shady business and deciding to just dissolve, right? Take out a bunch of loans or whatever, and then borrow people's money, do all sorts of transactions, and then disappear because they decide to file paperwork. No. That's not how it works. That is not how it works, and that's definitely not the intention of Florida State. Doesn't want you to do that. You have to give notices for your known creditors at the time. Now, how else can you, as a business owner, be responsible for the debt of your company? One of the things is, if you are signing on behalf of your company as a co-signer or guarantee. So you see that a lot of startup companies, LLCs and such, when you have a new business and you don't really have the backing of 2 years of financial or 3 years of financials to get a loan, what does the bank and other institutions ask you to do? You co-sign on it, right? Yeah. You co-sign personally on it. So we're talking about co-signing for a business loan. We're talking about signing a guarantee. Sometimes it's not just I co-sign on the loan, but I'm making a payment guarantee, right? It's a different document when you're signing as a guarantee, a guarantor for a payment. You see it also when I see it a lot with commercial leases. These commercial lease landlords, they know what's up. They make sure that not only does your business sign the commercial lease, but you almost always, I think every single commercial lease I've ever had also has where the owners of the business will sign. And I've tried to negotiate out of these, and I'm telling you, they are not budging, because this is what a lot of the commercial landlords do, is that they have you personally sign. Why? Because if the business ends up closing down the month afterwards, now you've signed this 5-year lease and the landlord is out. So they make sure that you sign as a payment guarantor. Now, can you go now to that landlord or the bank who gave you the business loan that you've co-signed on and say, well, my business didn't make it. I'm really sorry. I had to close. Here's my articles of dissolution. I've closed my business. I don't owe you any money. No, you've co-signed, so now you owe. So this is one of those incidences where you are now going to be liable for the debts of your business because you co-signed on it.
Wow.
So be very, very aware of what you're signing, either as a business owner or of you personally. So I know it's kind of like a very technical distinction to make, but I make it all the time for my clients when I do transactions for them. And I ask them, are you signing as an officer of your company or are you signing individually? Very important. If you're signing something that says a guarantee or a guarantor, if you're signing something that says a co-signer individually, you look at words like that, individually. If you're signing individually on a contract, that means that you're signing as you, the person, and not your company. So be very, very, very aware. And unfortunately, especially in the beginning of the pandemic, when people weren't able to really pay their commercial leases, like I know that the the state talked a lot about in early days of the pandemic about evictions, staying evictions for residents and stuff like that. But I'm not sure what they had said about businesses and commercial leases. But I know a lot of people were like, man, I can't pay my rent. And I've had people call me, I can't pay my rent. And I said, well, unfortunately, let me take a look at your lease. And lo and behold, you'll see the lease with all the terms. And at the end of the lease, you'll see them sign in as a personal guarantor. So once that's done, they come after you because now you've personally guaranteed it. So that's why I said in the beginning, generally speaking, you should be a separate entity. Generally speaking, technically you should be separate. But if you're co-signing and you're a personal guarantor for a business loan, a commercial lease, buying products, I mean, whatever it is that you may need for your business, if you personally guaranteed it and you're a co-signer, you're going to be liable because now they can come after you.
Right. The bottom line is you just need to consult with a professional. That's it.
Or just be aware of what you're signing.
Yeah.
Be very aware of what you're signing. And if you're not comfortable with it, then don't sign it. And I've been in situations where I can think of one space that I absolutely loved and I wanted to be in that space. And I tried for weeks to negotiate out of my personal guarantee. And the landlord was like, nope. I understand your point of view. I understand what you're saying, but this is our standard practice. We have all our tenants sign a personal guarantee. If you don't like it, you can go find somewhere else. That's what the attitude was. And I caved and I signed it. And I love the space. I mean, I absolutely loved it. But it just goes to show that this is the practice of a lot of commercial landlords. And again, I don't blame them because who wants to sign a lease with a company that's there for a month or two or half a year and then they decide to just file dissolution paperwork and leave? You're stuck. You're stuck as a landlord being able to figure out how to recoup your money. So this is definitely a device use. And the same as the banks, the banks aren't going to give you a small business loan unless it's collateralized or you co-sign on it, right? Which brings me to my second point. So one of the exceptions, if you co-signed or you signed as a personal guarantee. The other thing is, a lot of times they will ask you as a business owner to use your personal assets or the business assets as collateral for a loan. So if you're signing something and they say, well, yeah, we can go ahead and give you your loan for your business, but you have to collateralize it with your house, or you have to collateralize it with your personal assets. What do you have? A car, you have whatever, a boat, whatever it is that you may have. Or if you don't have any of those personal assets, we are now going to use the assets of your business. If you're a salon, and we always talk about salon, so I'm just going to throw out salon, you have 50 chairs, you have tables, desks, machinery, cash registers. Those are all assets that your company can have. If you're a bakery, you have these huge, ovens, and you have all these different machinery that if you default on your loan, let's say it was a loan from a bank, and they can seize your assets and sell it and make their money back. So you have to also be aware of what it is that you're signing, what you're signing as collateral. And for those of you, if you're a business owner, you should know what collateral is. It's basically something that you put up as security to get that loan. It's like, I'll give you my car if you lend me this. If I default on the payment, then you can take my car, something like that. So that's one of the exceptions too. And again, we're talking about separation of your business and personal, but if you've used your personal assets to go ahead and collateralize that business loan, that's another way that they can touch you personally, that they can come after you. Because you can say, no, this is my car, this is my personal car, this is not a business asset. But if you look in your documents and you see personal car, VIN number, whatever is used as collateral, then they can come after you.
Wow.
So be careful with that as well. You're shaking your head. Yeah. You're shaking your head. But, these are things that you definitely have to consider when you're going into business, right? So people think, well, I'll just dissolve my company and I'll be done with it. No, there's a lot of disputes that happen post-dissolution because people don't understand what it is that they need to do to be able to really just pack it up, put it in the corner, and be done with it. And if you are, let's say you took out a huge business loan from a bank and you have collateralized it with your personal assets, do you think that bank is just going to be like, oh, well, I guess the business didn't work out? No, I mean, there's a reason that they ask you for your personal assets, and there's a reason that they ask you to co-sign as well. So keep that in the back of your mind as something to think about. And all of these come into play with you thinking about whether or not you're going to dissolve, right? Because there are options, and we can talk about options afterwards. Well, hopefully we'll have time to talk about just quickly options. But these are things that I want our listeners to consider, because it's not just waking up one day saying, well, I guess I'll just dissolve my company and all my problems are going to go away. No, you have to think about all your other creditors that are out there, your debts that are out there, who can come after what. Because I tell you what, that's going to play into my decision making if I think, oh no, if I dissolve my company and I don't pay the loan, they can come after my personal assets. That makes a huge, impact on my decision making. So that's one thing. So the guarantee, the collateral is one thing. Another way that you can not have that separation, because we want that separation, but one of the ways that a creditor can prove to not have that separation is what we call in law piercing the corporate veil. Now, I can do an entire show on piercing the corporate veil, but I don't want to because it's very technical and I think our listeners will find it quite boring. But what that basically means is that a creditor can make an argument that you basically used your company as what they call in law an alter ego of yourself, meaning that it wasn't actually separate. It was just you in that company, and you just kind of used it as an alter ego. So because now this is not a separate entity, I'm going to come after you personally. And I've used it in arguments against people who have done it. So you might be wondering, well, geez, like, how do I know if they can pierce the corporate veil against me? The court looks at a lot of different factors, but one of the things that we've talked about in the past is that you always make sure that you don't commingle your funds. We talk about commingling. Commingling funds is one of the biggest issues with small business owners. Because again, especially if you're a sole owner and you got your business card in one hand and you have your personal card in the other hand, and for something or the other, maybe your personal card doesn't have money in it, but your business card does, and you go ahead and you swipe whichever one has money. No, don't do that. Because what you end up doing is you're giving your creditors, possible creditors, the ability to pierce the corporate veil and come after you personally. Don't commingle. Have a system in place for your business where you're paying yourself, right? Whether it's through, a W-2 employee, whatever the case, talk it over with your CPA. That you have to have a way of paying yourself. So once that money is paid to you in your personal account, you can go ahead and use it for whatever you want to use it for, and you have to make sure that business assets are business assets, business expenses are business expenses, and personal expenses are personal expenses. Do not commingle. That's one of the biggest ways that a creditor can show that they can pierce the corporate veil, because at that point they're saying, wait a minute, you don't actually have a business. You have an alter ego, meaning that you have another thing that's kind of just like you. You don't have an actual company that's separate. Right? So that's what they're going to try to prove. The courts also look at, just to give you an idea, if the owners exert a lot of control over your LLC, if you've commingled funds, they look at your corporate formalities. Big deal when people are saying, well, it's just me and my company. Why should I have a corporate resolution? Why should I call a meeting? Do I just call a meeting by myself? And they chuckle and I go, yes, call a meeting by yourself. I mean, it shouldn't be hard. You don't have to wait for availability for anyone else. Just call the meeting by yourself and just document. So I get those questions all the time and people chuckle because it just sounds ridiculous. And, I see it from their point of view, how it does sound ridiculous, but I'm looking at it through the lens of a corporate law attorney. So for me, it's not. For me, it's like, have those minutes, have that meeting, pass that resolution. Because if it comes down to the creditors trying to prove whether they can pierce the corporate veil, I can pull out a book of all the resolutions that I've passed, where I've made decisions for the company as a board of director, as a shareholder. I have all these resolutions because I did things separately, because it's all about separation, right? You did things separately as a company than you would have done personally. So corporate formalities are very important for corps and incs. You know, have you followed all those formalities? If you have not, start thinking about doing that now and putting things down in writing and passing those resolutions, because you never know when the day comes where you have to produce them. And it's easier when you're the only director and shareholder, because you don't have to coordinate meetings with anyone. Exactly. You just have them by yourself. You just have them by yourself.
I wouldn't have that problem because I enjoy talking to myself. So.
Yeah. What is the saying? It's like talking to yourself is not an issue. It's when you start answering yourself that's the issue. Like, look, I have full-on conversations by myself all the time. I think out loud. So if I'm trying to think through a problem or an issue for a client, I'm just sitting there mumbling to myself, and my husband goes, "What?" I go, "Oh, no, I wasn't talking to you. I'm just,
that is kind of crazy." Mark does that all the time.
Yeah.
He does it too, and I say, "Huh?" And he's like,
"No, I'm not talking to you." Tell Mark that's how thinkers think. That's how we are. We're constantly thinking about something or the other. But yes, piercing the corporate veil. And another way, because I'm looking at the clock, another way that you can have creditors go after you personally and not your business if they detect fraud. 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 Like I have taxes. Mm-hmm. Fraud. Because it's very, very important. They're going to look at whether or not you entered into that loan under a fraudulent cause. So let's say you took out a company, you incorporated a company just to get a $50,000 loan with your intention and is to defraud the bank and just close up the company and leave. If you do that, don't think that you're being smart, because there is an exception with fraud, is that they can come after you as the owner of the business. So don't think that you've gotten away with one. You have not, because fraud is one of those things that allows a creditor to go after you personally. Let's see. Now, quickly, if you listen to everything I say and you go, "Oh my gosh, I can't believe it. Dissolving my company won't actually solve my problems," right? As I thought they would have. Maybe this dissolution is not for me. You can also think about doing other things. So I've advised clients in the past that have had these issues where, "Oh no, I'm still going to be liable." Think about selling your business. You might think, "Well, I have all this debt, I don't want to sell." Look, it's either can't produce and still be liable for all these debts, or try to sell it and get some money for your company, because you have assets. You might not think that you do, but like your customer base, depending on your industry, might be an asset. You may have furniture, you may have whatever, trademarks. You may actually have a couple of trademarks under your belt that brings value. Intellectual property is an asset.
Merchandise.
You may, what's that?
Merchandise, like
merchandising. Whatever the case may be, you may have things that you're not considering to be an asset, that you sit down and then you figure out, "Hey, this is worth something." And you might want to sell, and you can find a buyer, and we can have I might actually do a whole show on just how to sell your business, because that's another little sub niche of how to do things. Yeah. The other thing that you can consider is bankruptcy. If you find that, I really I can't sell it, I have no value that I can get out of selling my stuff, I just can't pay my debts, I'm just going to file bankruptcy. Now, bankruptcy law is a whole niche upon itself as well. And I think that I don't do that for my listeners out there. I'm not a bankruptcy attorney, but I think that I may reach out to one to be able to have a show on doing bankruptcy, just business bankruptcy, because that's also very different from personal bankruptcy.
Yeah, I think that would be a good idea, because like many people, myself, I was under the impression that, because looking at somebody like Donald Trump, you hear how many bankruptcies he's filed. Yes. He's a multi-millionaire. I'm like, wow. So maybe there is a method to the madness. And I think a lot of people are under a lot of misconceptions about bankruptcies. So I think that would be a great episode.
Yeah, I think so too. And I hear you with the Donald Trump thing, because you would think that, oh, you hear the word bankruptcy and you think no money. You think, oh, they're bankrupt. They don't have any money.
Right.
No. He was very masterful at separating personal from business. That's what it was. So his businesses can be in bankrupt, but him personally doesn't have to be.
And
Right?
guys, this episode is not to teach people how to be a crook.
No.
Okay? Let's just put that out there right now.
No. And I am in no way glorifying his business bankruptcies or him. I just want to make that clear, like exclamation point. Not a fan.
No.
So no. But in the way that it was presented was like, he's even said it in the debates, like, I'm smart. I did this because I'm smart. He said it in the debates. So I just want to say that the personal bankruptcy is different from the business bankruptcy. Your business might not be doing too bad, but that doesn't mean you don't have a nice house and a car and a yacht and a whatever, just because your business isn't doing well. Because some people have multiple businesses as well, which is the case of Donald Trump as well. Right. You have multiple businesses. So if one isn't doing well, doesn't mean that the others aren't either. And if you keep them completely separate, we're talking about separate legal entities again. So I think that I may try to find someone who does business bankruptcy so that we can get a consult on that, because I don't do them. And I think that would be a good resource as well for our listeners out there. So those are some alternatives too. If you've listened to my show today and go, nope, not dissolving, I can't afford to do that either. That might be a good thing for you to consider selling or doing some sort of bankruptcy as well. So now that I've hit my hour of information, it's 5:00. I just want to say for the bottom line, really think carefully about your decision. It's not just a matter of filing something and having your problems go away. It's rarely ever that simple in business and in law. It's rarely ever that simple. Let me just file something and be done with it. Make sure that you really think long and hard about the consequences of what you're doing. Make sure you have a plan. So what next, right? So I do the whole winding up. I liquidate my business. I do whatever procedure fits me. And what's your plan afterwards? What are you going to do? Because that will affect how you decide to make your decision now as well. Make sure that you do it properly. Whatever you decide, make sure that you do it properly, compliant with the law, and do your research, hire the professionals that you need to hire, and make sure that you take your time to figure out what you want to do, because success comes when you're minding your business.
The content on Minding Your Business is for informational and educational purposes only and should not be construed as specific legal advice. This show discusses general legal issues affecting business owners. Opinions of the guests are not necessarily that of the show. If you need assistance with your specific legal issue, please consult with a licensed attorney.